Hello and welcome to this episode on incorporation of companies and the provisions relating to it in the Companies Act 2013. To discuss this with us, we have with us Ms. Alka Kapoor, Director of ICSI, and Mr. Elam Kamboj, Group Company Secretary for the Hero Group. Can we begin by discussing the process of forming a company? What comes first? What happens next? How does one go about forming a company?
See, if two or more person, so for the name is concerned, the law says that the name in the memorandum should not be such which is identical or very similar to the existing company, and the use of which is constituted or treated as an offense under any provision of any law, or which is undesirable, the use of which is undesirable in the opinion of the central government.
Right.
So that kind of name you cannot use. Further, you cannot use that kind of word or expression in the name which gives an impression to the public at large that this company has some connection with the or some patronage of the central or state government,
Right.
or it is connected to some local authority or some body or corporation floated by the central or state government, or any other word or expression which may be prescribed by the government, which cannot be used in the name unless until you take prior approval from the central government. Once you know that this kind of name only can be used, then you apply to the Registrar of Companies by submitting complete details and all documents or information. And once the Registrar of Companies sees that the documents or information provided by you are adequate, then he may reserve the name as asked by you for 60 days period.
60 days.
60 days period. The detailed guidelines of this name availability are given in the draft rules also. So once this name is reserved for you, you can use it later on. And if later on it is found that the name which you got reserved was acquired by submitting wrong information or wrong details, then the Registrar of Company has the power that in case of a situation that company has not yet been incorporated, he will cancel the reservation of name, and he can fine the applicant up to rupees 1 lakh. And if the company has already been incorporated, then he has power either to direct the company that you change the name within 3 months after passing an ordinary resolution, or he can initiate the process of striking off the name from the Register of Companies, or he can file an application for winding up of the company. However, these steps can be taken only after giving an opportunity to the company to be heard.
Of being heard.
And once this process is over, then the next step of incorporation takes place.
Right. So what happens next after the name?
Yeah, once the name has been reserved for the company, the next step is to file certain documents with the registrar. In fact, the new act provides for very speedy incorporation, but of course with detailed disclosures and declarations. The first thing is to draft memorandum and articles of association. Then the documents which are to be filed with the ROC include memorandum, articles, a declaration by either the director or secretary of the company, or by an outside professional, which could be a company secretary, a chartered accountant, a cost accountant, or an advocate, saying that all the documents and the information provided therein with regard to the incorporation is correct. In addition, these were in fact the documents which are required under the 56 Act also to be filed at the time of incorporation. But in addition, certain detailed disclosures have to be made in terms of the particulars of directors and the subscribers, their names, their surname, their family name, their residential address, in the case of directors the SIN number, their proof of identity, all this has to be filed also with the registrar. And this detailed disclosure with regard to directors and subscribers and promoters has been put only because of the experience of vanishing companies. See, we know there were many fly-by-night operators. Many companies vanished after incorporating and taking money from the investors by issue of prospectus. So, to curb that, the government wanted detailed disclosures of the directors and the promoters.
Right.
Another declaration which is also to be filed, that is by the subscribers to the memorandum, and they should, and also the first directors, they should state that they are not convicted of any offence in conviction with regard to the formation or incorporation of any company, or that they have not been found guilty of fraud, misfeasance or breach of any duty with regard to any company, wherever they might be the directors or promoters, and also an affidavit to the effect that correct and true information is being provided through the documents which are being filed. A registered office of the company may not be there at the time of incorporation, but the company has to give an address for correspondence. Yes. Once all these particulars are filed, the company is incorporated by the registrar. The registrar issues a certificate of incorporation to the company and also gives a SIN, which is the corporate identification number, to the company. The SIN is also indicated in the SIN number is also indicated in the certificate of incorporation. Once a company gets a certificate, the proof is that company is incorporated.
So, once a company does get incorporated, you go through all this process. What if it's found that anything given in this process is untrue or misrepresented or fraudulently presented? What are the consequences?
There is a very severe penalty which has been provided in the Companies Act 2013 to prevent the fly-by-night operators from incorporating companies by giving false information. Besides giving detailed information, still if it is found that any information which was given was incorrect, the punishment is in terms of fraud. The directors or the promoters or the subscribers to the memorandum will be considered as having committed a fraud under section 447. And we all know that the punishment for fraud is not less than 6 months, which makes 10 to 10 years, and also a fine, which is equivalent to the amount of fraud, or which can even be up to 3 times that of fraud. In addition to that, if any person makes an application to the tribunal saying that the company has been fraudulently incorporated, the tribunal has the 3 options. Either it can ask the company to be wound up, or it can ask the name of the company to be removed from the register of members, or it can also make the liability of the members as unlimited.
So, this can be done by the registrar? We can move the tribunal?
Yes, he can also move the tribunal.
Just to add here,
correct.
The tribunal has the power even to regulate the management of the company. And if the tribunal feels that it is in the interest of the general public or in the interest of the company or its creditors and the members, the tribunal can order for the amendment in the memorandum. So that can also be done.
But actually very stringent provisions are there for mis or wrong information.
This is very stringent.
Yes.
What happens if after forming a company you want to change the registered office, or you want to change the objects? Anything to do with the memorandum and articles need to be changed?
See, if we go by the sequence, once you have incorporated the company, you want to start the business now, So you have to have the certificate of commencement of business.
Right.
Earlier it was not applicable on the private limited companies, but now it is applicable on all kinds of company which has share capital. And they cannot start business unless the certificate is there. But for getting the certificates, a director of the company has to file a declaration that the subscriber to the memorandum has paid money with respect to the shares which they have promised to take as subscriber. And on the day of making this kind of presentation, this kind of declaration, the paid up share capital of the company was not less than 5 lakhs in case of limited company and not less than 1 lakh in case of private limited company. And further, that the verification of registered office has already been filed with the registrar of companies. Once this kind of declaration is filed, then the ROC issues the certificate of commencement of business. If you incorporate a company and don't get the certificate for 180 days, then the registrar has the power, after seeing that he has the reasons to believe that the operations have not yet been started or no work is going on in the company, then he can cancel the
Suo moto. Right.
He can initiate the process of removing the name.
Right.
Once it is done, now there could be a situation that you want to shift the registered office. Shifting of registered office has different version. One, within the city you want to shift the office, then just pass a board resolution and shift it. It is over. You want to shift the office from one place in the city to the outside the limit of the city.
Right.
Then you have to pass a special resolution. You want to shift from one city to another city in the same state, but under the jurisdiction of from one registrar to another registrar. Then in that situation, after passing the special resolution, this has to be confirmed by the regional director also.
Right.
Now the situation is where you want to shift from one state to another state. Then besides passing the special resolution, you have to take approval from the central government, and this approval from the central government along with this special resolution need to be filed with both the state governments, the registrar of both the states, and the registrar of the state where you are going now, the new state. He will issue a fresh certificate of incorporation. That's how the complete process of shifting the registered office takes place.
Right.
Just to emphasize what he's mentioned, although he's already mentioned with regard to verification, see, this clause was not there earlier. The companies could shift their registered office as per the procedure, but an external verification by an outside professional is now required. First, that the registered office is there, and if there is any change or shift in the registered office, then with regard to that shifting also, that with regard to that this is the new place where the registered office is there. It is to be verified by an external professional.
And then if you want to amend the articles, amend the memorandum with respect to object clause, alteration of object clause in the memorandum of association. Now it again has a very serious provision with respect to that. First of all, now in the objects there is no classification of objects, as it happened earlier that there are main objects,
main objects and ancillary objects,
and then other objects. Those are not there now. Only the
objects
and the matters which are incidental to in furtherance of that object.
Right.
Second, if still you want to further amend them, then in case of those companies which has taken money from the public by way of issuing prospectus, and if any amount of that money is still not utilized, it is unutilized portion is there, then the object for which you have taken that money cannot be amended unless you pass a special resolution,
Right.
and then this special resolution is published in the newspapers, one in English and one in Hindi or vernacular language, and it is put on your website giving justification for the change, and further, if there is any dissenting shareholder,
Mhm.
he don't want to agree with your amendment, then the promoters or the shareholders who are in control of the company, they need to give him exit option.
Right.
So once it is done, then only you can amend the memorandum with respect to objects, and then the registrar, he will issue a fresh certificate registering the amendment,
Right.
and the amendment will be effective from the date of certification from the registrar only.
Is there any other aspect that makes a differentiation? Like, what if it's a one-person company? What if it's a charitable company? What are the aspects to bear in mind in the process of incorporation, depending on the nature and character of the company?
Okay. See, there is a change. One-person company, as we all know, has come for the first time, this concept. If a one-person company has to register itself, it has to follow the due process of filing the memorandum, articles and all that. But only thing is, the only addition is that a one person may not be there for all the times to come. There may be his death, or he may become incapable of making a contract. Therefore, the section provides that the one person has to nominate or identify another person who will become a member in case of his death or incapacity to contract. But of course, the consent of that other person has to be obtained and filed with the registrar. The other person can even withdraw his consent by following the prescribed procedure. The member of one person company can even change the name of the other person and put another person in his place. But of course, the intimation has to be given both to the company as well as to the registrar.
Right.
And where a company is incorporated as a one-person company, then below the name of the company, in brackets, it is to be written one-person company or OPC.
Right. And what about charitable companies and companies that are not for profit?
See, this is a concept which earlier used to be Section 25.
25.
Now it is Section 8 company.
Hmm.
And Section 8 says that if any person or association of persons, they want to float a company with the charitable objects, some of the new objects have been introduced only in the recent act, such as education, research, social welfare, then protection of environment, etc. Then in first the object should be charitable, then the income or the profit of that company shall be used only for these objects, and there will be restrictions on the distribution of dividend. If these three conditions are met, then the central government may issue license to the maybe the license is issued subject to certain conditions,
Right.
and then allow them to be registered as Section 8 companies. Then they can approach the registrar of companies, and on the application to the registrar of company, the registrar may register them under Section 8
Right.
as charitable company. Similarly, for existing companies where the central government is satisfied that the object of the companies are charitable as mentioned in Section 8, and they have restrictions and conditions of non-sharing of profit by way of dividend, they can allow them also by
Right.
issuing license, and they can approach the registrar and get themselves registered as Section 8 companies. These companies will be registered as limited companies, public limited company, though without using the word limited or private limited.
Right.
One peculiar thing that even the firm can become member in these companies.
I see.
And these companies will enjoy the privileges of public limited company, though subject to the obligations also as applicable on the public
Limited companies.
The memorandum of these companies, memorandum of association of these companies cannot be altered without the approval of the central government.
Right.
Reason being, the central government has issued the license based on certain things. So they will look into that whether that will be complied with or no. So memorandum you cannot change unless you get the approval from the central government. If you want to convert this particular company in some other class of company, that is possible only after complying with certain conditions, which is a precondition. You have to comply with certain conditions which may be, though these are not yet prescribed,
Right.
but may be very critical and very, very severe conditions. And once this charitable company under Section 8 is floated, then the central government will look into the working of this. And if later on it is found and central government is satisfied that the conduct of the company is not as expected, not as per those objects, or it is running fraudulently, or it has been floated by providing certain wrong informations, then the central government can revoke the license.
Right.
And once the central government revoke the license, they can further order for either winding up of the company or amalgamation of the company. The amalgamation of charitable company can be done with the company only, which is again Section 8 charitable company.
So
The
one
same
charitable company can merge with another.
Correct. Not in other.
Right, not in any other form.
If the company is to be amalgamated, then the central government can provide that the new company will be subject to following privileges, rights, obligations, liabilities, and it will be a single company.
Right.
If it is to be wound up, then first the debts and obligation of this particular company is to be satisfied, and if thereafter remains any asset, then those assets can either be transferred to some other company floated under Section 8 as the tribunal may decide, or those assets may be sold and the proceeds of that can be transferred to the rehabilitation fund.
Okay. So,
So one thing which is important in this case is that is the penalty provision, which is very, very high. If you contravene the section, then the minimum penalty is 10 lakhs rupees.
okay. Minimum.
Minimum penalty is
It's fine or
And
penalty?
maximum
it
would
is
be?
fine.
Fine.
It is fine, and the maximum could be 1 crore rupees.
Right.
Massive.
And the imprisonment to the officers who are in default
Right.
could be up to 3 years.
Okay.
And the officers can further be fined for minimum 25,000 rupees, which can go up to 25 lakhs rupees, or with both imprisonment as well as the fine. And if it is found that the affairs of the company were conducted in fraudulent manner,
Right.
then Section 447
Will apply. The general fraud section will
general
apply.
fraud section will apply.
Right. What about companies of one form wanting to become another? Like say an OPC becoming a private company, or a private company becoming a public company, or public company becoming private company. What are the provisions that deal with these, and
You can
how does
alter.
it work?
It can be altered. From one form of company can be converted into another. Only thing is, if you are converting a private company into a public company, then of course the special resolution is required. But if you are converting a public company to a private company, since the private company is subjected to lesser stringent provisions, then the approval of the central government is also required.
Right. So, but it is possible. It's not
It is
as
possible,
if you,
yes.
And then the central government approval along with the special resolution need to be filed with the registrar,
Yes.
and then registrar will issue a fresh certificate of incorporation.
right. Is there any other aspect that we should talk about before we wind up on this aspect of the charter of the company and its
Okay. One is which
incorporation?
relates to professionals, which I would like to highlight. As we all know, a declaration has to be formed at the time of incorporation, which could be by an outside professional, a chartered accountant, a company secretary, cost accountant, or an advocate. The earlier provision was that it could be filed by the outside professional or by the director, manager, or secretary of the company. And this declaration is with regard to the effect that all the requirements of the Act and the rules with regard to incorporation have been duly complied with. The change provision is that the declaration has to be filed by both the outside professionals as well as the director, manager, or secretary of the company. So the word used is and instead
yeah.
of or. So the role of
So they
outside
all have to
professionals has also
be
been
able to
enhanced.
sign off and
Yes,
say.
yes, yes.
Right.
And if anything goes wrong, then the person,
Then the professionals are
including the
also liable.
professional, you know,
So
they
the
are held
fraud
liable.
provisions and all would apply
Yes,
to
yes,
the
they'll apply to them
professionals as
also. Correct.
Is there anything else we should talk about in summary before we conclude?
So anything you would like to say?
You see, the advice to the company secretaries is
Yeah.
that we must go through the act carefully, we must go through the rules carefully, and don't take any shortcut. Provide the correct information, adequate, correct, full and true information to the
Right.
registrar. Don't make any wrong statement. Don't try to conceal any fact. And if you do that, you are taking a very huge risk
Right.
as a professional, as a director, as a subscriber. Not only the penalties in normal course, but the penalties under fraud
Right.
will be applicable on you.
The consequences are severe.
Consequences are very severe.
Right.
So therefore, one has to be very careful.
Good. I think that's all we have time for in this episode. Thank you very much
Thank you.
for outlining
you.
the whole process of how to form a company. And thank you for watching this episode on incorporation. You would have seen specific provisions being highlighted during this video. Please do read these provisions. The idea of this video is only to give you a primer on what these provisions are. Thank you very much for watching.